How does a community property agreement affect divorce? Have you ever wondered how a community property agreement can impact a divorce? This topic is important for anyone navigating the complexities of marriage and property ownership. A community property agreement, often referred to as a CPA, establishes that property acquired during marriage is owned equally by both spouses, typically 50% to 50%. This means that when a couple decides to divorce, all community property must be divided equally according to the agreement. Community property generally includes income, real estate, personal property, retirement accounts, and debts accumulated during the marriage. However, separate property, which includes assets acquired before marriage or received as a gift or inheritance, is usually not included in community property unless it has been mixed with community assets. The CPA can clarify or modify these default rules if both spouses agree. During a divorce, the community property is dissolved and divided equally. However, the CPA remains effective until the divorce is finalized. This is important because if one spouse passes away before the divorce is complete, the surviving spouse may still inherit their share of the community property under the CPA. To terminate the CPA before the divorce is finalized, both spouses must give their consent. From an estate planning perspective, a CPA can help avoid the probate process by allowing property to pass directly to the surviving spouse upon death. This can simplify matters during a difficult time. However, in divorce situations, it ensures that community property is divided equally and may complicate property rights until the divorce is legally concluded. In summary, a community property agreement confirms that property acquired during marriage is owned equally by both spouses. Upon divorce, community property is divided equally, and the CPA governs this division. The CPA remains in effect until the divorce is finalized, affecting property rights and inheritance if a spouse dies before the divorce is completed. Separate property is generally excluded unless it has been commingled with community property. The CPA can simplify estate planning by avoiding probate but requires careful consideration during divorce proceedings.